Owner Patricia Weisleader is here today to address the board as well, so my presentation may be a little longer on this one. This case is for a statement of abatement costs for a violation of ordinance number 457, which involves substandard mobile home. The mobile home on her property had faulty weather protection, general dilapidation or improper maintenance, and public and attractive nuisance. Two options available to her were to either rehabilitate the property or to demolish it. As of March 17, 2015, the violations remained unchanged on her property. We did have a chance to speak with Ms. Weisleader outside, as she was here earlier. However, we could not come to a resolution. She raised several issues that it's not related to the code issues, and it's not related to the matter before the board here today. She had a federal case that she had filed, but that case had been dismissed by motion. She claims in that case no attorney's fees had been awarded, but the attorney's fees addressed in that federal case are attorney fees specific to that federal case, which is unrelated to our case here before the board for statement of abatement costs. She also refers to Ordinance 348, Section 19.79, which refers to mobile homes not on foundations. And part of that section says the mobile home not on a foundation is allowed whenever it is specifically so provided in the various zone classifications in the county ordinance number 348. Referring to the section, she is saying that her mobile home is permitted, but her zoning is under W2 zone, which is a controlled development zone. And in that zone, for mobile homes to be permitted, there has to be an approval of a plot plan, and that's an allowance of an additional one family dwelling for each 10 acres being farmed. Her property total is 9.35 acres, therefore that provision does not apply. And for a mobile home to be considered outside storage, for properties 1 acre or more, it's limited to 200 square feet with a maximum height of 3 feet. So she does not qualify under either of those provisions. And the more important thing is that this is really a distraction because she was issued a notice of violation under 457, which is based on the condition of her mobile home, not necessarily the existence of that mobile home. And 348 is actually referring to the existence of a mobile home. So she needs to bring under 457 the substandard conditions up to code. Also, she had referred to section 19.80 under 348, stating that the mobile home is permitted based on the zones listed there. However, under 19.80, it says W2M. Her zone is W2, not sub W2M. Therefore, that does not apply as well. She also raised an issue with the inspection done by code enforcement of her property. However, there has been no issues relating to inspection, as code went onto the property on November 30, 2010 and attempted contact with the property owner. Instead of going onto the property from the road right away, the code officer saw a mobile home with missing windows and doors, and he posted a business card and had left. Then on December 9, 2010, he posted a notice of intent to inspect at the entrance by the dirt access road. And on December 14, 2010, Ms. Weisleader did not grant permission to inspect, and at that time, code enforcement applied for an inspection warrant and was served on February 9, 2011. And the billing for the SOACs on this property is from the time of the inspection warrant. So we would ask the board to approve as recommended.
Okay. Just a second, Supervisor Worsen, do you have a question, Supervisor Benoit?
I do have a question. At the beginning of your report, you stated that the owner was referring to some potential awards of funding coming out of a lawsuit. Was her intent to suggest that that would provide her with funding to pay the county's bill on this?
The federal case was an action that she had filed for vindictive prosecution and other claims related to this code enforcement case. But that case was dismissed in federal court already, and the attorney's fees that she's referring to is actually attorney's fees related to work done for that federal case, not for the abatement costs in this particular SOAC hearing.
Okay, thank you.
Supervisor Benoit?
Yeah, do you have photos? This seems to hinge on the appearance, and I haven't seen any the photos yet.
I do have several photographs. These are photographs from 2010. Photographs from 2010 showing the mobile home, and it's in substandard structure. It's a substandard mobile home. This is more from 2011. Here. These are also from 2011. There. This is also from 2011 in February.
Thank you. Also, I believe you said that the charges that are currently pending begin with the day that we served the warrant.
Yes, it was from the date that the inspection warrant, so the inspections that were done prior to the inspection warrant, the code enforcement department had not charged for.
Why is that? When you have officers there ready to do their job and they're refused admission, that obviously generates additional costs. They now have to go back and make that trip again. Why are we not charging for those periods of time?
I believe code enforcement decided to start from the inspection warrant.
Generous. Okay.
I'll get an answer then.
Thank you.
Okay, we have the Patricia Whitewriter here. Okay, I knew I was going to get that wrong.
I have some packets here that have evidence, including photographs
Now, come on up.
showing that.
I need some help. No, stay there, not up here, stay there. Yeah.
Go to the microphone.
You'll end up with the sheriff grabbing hold of you. There we go. Okay, we won't start your time until you're ready, so. Give her this microphone. Here, hold on.
This is,
Hold on, we'll get you.
this one.
No, she's got it.
Okay, go ahead.
Go ahead, okay. First of all, the citation which, that was given to me on the mobile home was a citation for the abatement of mobile homes in or around the a mobile home park or a special interest occupancy park. And now, I moved onto the property in 1989, in which time W-2 was W-2. Now, they have changed, they've added other letters, but included in the evidence I've provided, it shows that the officer said that my property was zoned W-2 in 1980, I think, and it has never been changed. And at that time, I was told that this mobile home on the property, that I couldn't live in it, but it could be there forever. No. And that section has not been revoked. Now, that ordinance says that addresses the older properties and says that the zones where mobile homes are allowed not on foundations, which and it mentions, it says W2H, but these days they never say W2. You know, and before when I moved here, that was all they said was W2. It says that the order specifies nonconforming mobile homes cannot be altered. However, there is no specific time in which the mobile home must be removed. Now, the claim that being unstandard was basically, he said all the windows were out. And if you look at the last page of the attachments you'll see photographs of that the windows have always been there, they're still there. Now, when she said that they are only charging me from the time of processing the warrant, so I didn't know they'd been on my property. I'm home like 6 days out of the week, but the pictures that were provided for the federal case showed the officers' vehicles on my property in places that could not be observed by the street. And I think the idea is they were trying to tell me that since they hadn't charged me for conducting the illegal searches, it didn't matter that they had occurred. Now, the federal law, which when I removed it to federal court, the reason was at that time that they had given me like $7,000 worth of citations, which they had to be paid before they could be appealed. Well, I'm disabled and I have a low income, and I removed the case to the federal court based on the idea that I have a right to an appeal. And now this is going on for 25 years, about every 5 years. And when you don't have a lawyer, everything's dismissed in federal court. As a matter of fact, my farm, or my land the judge decided was flat farmland, and that anything could be seen from the street. Well, that's not true. And anyway, the documents there show that the officer, he provided the paperwork which was presented to the federal court showing my land is W4 and always has been. And yet he cited me on a violation that was for in or outside of a mobile home park, which the lawyers out there feel that being outside of a mobile home park includes all of Riverside County, and that it somehow negates the law for the mobile homes on W2, which say you don't have to remove them. I mean, we're talking 300 miles from the street, and the windows aren't out, even though there's included there is the affidavit for the warrant, which he's, after being on my property 4 times over most of a year, as long as he wanted, going anywhere he wanted, he knew that the windows were still in the mobile home, and yet he signed an affidavit under penalty of perjury saying that the windows were out, which was pretty much the basic point. As far as the pictures of trash stuff, much of that was cleaned up before that ever happened, because I had a major cleanup to do and I had hired help. And also, they informed me they went on my property 2 weeks ago without me knowing and took more pictures, which they have not, they won't provide them to me. They said I have to file a FOIA request in order to see those pictures. So, now, let's see.
Can you sum up? We've given you a little more time than. We've given you more time than you're allotted because we knew you had a lot to say. Could you sort of sum up your comments now?
Okay, they have been giving me the same citations about every 5 years for 25 years, different people, and most of the time in federal court, I would remove it to federal court, always for the same reasons. And the county's lawyers would say that the officers who had done the illegal searches no longer worked for them, and therefore, they had no knowledge of it. Well, this has been 25 years, and all of these forms and stuff that they would nail to my mailbox had supervisors and their supervisors all approving of this, and all of them know that that law does not apply to me. Okay, the mobile home has the wind-open windows. In one point, which is the south side, when the street's on the north side, there were 2 glass slats out that I had put in, and one fell out again. Okay, the man, all the windows other than that one slat, all the windows and the doors are there, and yet he swore an affidavit saying they were missing in order to get that search warrant. I believe that the lawyers I talked to outside today they think it's just fine to use a law that's for trailers inside or outside of mobile home parks, to apply to the completely open desert, which you'll see a picture there. I'm like in the middle of nowhere. There's only 6 houses on the section that I live in. And almost nothing can be seen from the street.
Okay, well, okay, thank you. Thank you for your comments. And
Thank you.
I appreciate you coming this distance to talk. And you can have your seat. Okay, anybody else here wish to speak on this matter? If not, we'll close the hearing. Supervisor Benoit.
Thank you. I appreciate the passion of the complainant. However, she did refuse to allow people on the property. That adds to the cost of the county enforcing code and other ordinances. Obviously, this is a piece of property that is in disrepair and very unsightly, and I'm sure we receive complaints of that type of property, and maybe this one specifically on a regular basis. The officers are doing their job, and obviously the petitioner has had an opportunity to make all these same arguments in front of a court that has denied her before. So I would ask her to please work with county code enforcement to resolve this issue, but in the meantime, I recommend approval of the recommendation that we move forward with the staff recommendation.
Okay, seconded by Supervisor Tavaloni. Supervisor Worstein, do you have any further comment?
I have one question for staff.
Okay.
At the beginning of your report, you characterized the property as also as an attractive nuisance. Is that correct?
Public and attractive nuisance.
Okay. And in my mind, when I hear attractive nuisance, I think of kids getting themselves into a dangerous situation, having access to something like an abandoned refrigerator that they get trapped in, or into something that poses a danger to someone under the age of 18 and to a minor typically. Is that what you're referring to when you say?
It was for it being an abandoned and vacant structure on the property.
Well, what is the definition of attractive nuisance?
Good afternoon, Supervisor. Hector Verai, Supervising Code Enforcement Officer. We don't have a specific definition for an attractive nuisance. What we do have in the county is what we call a public nuisance. Whenever a property is in violation.
You characterize it as an attractive nuisance, so I'm assuming you have a definition for that. No?
Not in 348, not in the county zoning ordinance. There is no exact definition of a public nuisance, attractive nuisance. But we akin an attractive nuisance to a public nuisance.
Okay. I think we're on the same page here. That would be also a level of concern that I would have. I think a property owner has an obligation, even if there's a standard that you want to reside in that seems to be below what normally would appear to be acceptable, there's an obligation also to those who might have access to your property to prevent people from becoming harmed on your property, in your property. In my mind, thus, the need for doors, windows, et cetera. So I just wanted to ask that question and get some clarification.
Okay. Okay, I think we're ready to vote.